All right, let's take the example of Bob. Bob is a very simple estate plan. He's got a will, he's got a transfer on death deed, he's put beneficiaries on all his accounts, he's got his power of attorney, he's got his healthcare directive. He's pretty much set. He doesn't need a revocable trust, but he's still going to be able to avoid probate. Except at the end of the meeting with his attorney, he says, what about my single member LLC that I use to manage real estate, right? Well, since the real estate is owned by the LLC, that's not in my estate, correct? And his attorney blinks a couple times and says, well, the real estate is not in your gross estate, but the value of the LLC, if you're the sole member and owner of it, that is in your gross estate. And it will pull you right into probate unless we do some basic business succession planning. My name is Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. And today we're going to look at some very basic business succession planning for single member LLCs. This is something I run into a lot. We have a lot of people own like a single family home, they put it in an LLC, they rent it out, or a duplex or something along those lines, and they still have to manage that as part of their estate plan. Now, there's a lot of complicated issues with business succession. There's going to be inter vivo succession, which is why while someone would sell the property, or sell the company while they're alive, and then there's got to be a valuation and a buyout and possibly a buyout over a series of years. There's multi-member LLCs and multi-shareholder companies and partnerships where you have to deal with potentially a non-partner coming into the company, and how do you do a stock buyback and how do you finance that buyback. Today we're going to look at a very basic business succession for a single member LLC. To do this, I want to back up a little bit and look at what we're doing in estate planning in general. For an individual, we're looking at 2 times in the individual's life while they're alive and incapacitated, and then after they pass, which is legacy planning, in 3 categories of things. We're going to look at their assets and finances, we're going to look at their health and body, and we're going to look at their minor children. Now, a business is going to be similar. We're still going to look at incapacity planning as well as post-mortem legacy planning. And we're still going to look at finances and assets. We're even going to look at the health and body of the business, which would be the operations and procedures of the business. Now, minor children, you could probably find some way to stretch the analogy to fit that in there, but we don't necessarily need to do that right now. For a single member LLC, we're going to accomplish the business succession essentially with 3 documents. One will be the transfer resolution or a transfer provision. Second will be a durable financial power of attorney. And third will be an operations and procedures manual. And let's take that in reverse here, just because I think that's what makes most sense here. Let's look at the operations and procedures first. This is something that I find that most single member LLC owners do not have written down. And why don't they have it written down? They're the only employee usually. They know that if they own a rental property, if something happens with the plumbing, they call Acme Plumbing, and if something happens here, and they know their accountant, they can always go to their accountant for tax advice and yada, 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 and it's in their head. And so they haven't written it down, which makes it very, very difficult to transfer the property to somebody else in an emergency. They always like to think, oh, I'll just sell the property and I'll do all the work then. But we're looking at emergency situations where someone is abducted by aliens or incapacitated for some reason. Another thing that they need to make sure to include, in addition to detailed operations and procedures manual, will be contacts, vendors, advisors, fiduciaries, clients, key contacts and how to get a hold of them. Nomination of the obvious one, nomination of who's going to manage the company during incapacity or after your death. Make sure to notify them so they're not surprised at this. I think that'd be obvious, but it is not obvious apparently. One of the big things that need to be done is passwords and accounts. A digital asset list where we say, hey, here's how you get in the company email, here's how you get in the company server, here's the bank records account. Importantly, it's really important to remember that even though it's an emergency, that doesn't extend beyond the individual generally. What I mean by that is you owe a vendor rent, you still got to pay it on time, right? You got to collect money on time, or you can waive certain rights. You've got to keep the operations moving for the company. So somebody has to be able to step in your shoes. Yes, it may be rocky. Yes, the shoes may not fit perfectly, but they need to be able to start running pretty quickly. The second document we're going to look at is the durable financial power of attorney. Very simply, this is what we're going to use to access the banking and online banking of the individual, or of the company. Now, in this case, we are not going to use a general power of attorney. If you watch my other videos, you are familiar that in Minnesota we have 13 enumerated powers. And if you give all those powers to the individual, to the attorney in fact, then it's a general power of attorney. And if you have fewer than 13, it's a limited power of attorney. Now, of the 13 powers, that's going to include everything from fiduciary transactions to business transactions to claims to finances and assets, personal property, real estate, et cetera, et cetera, et cetera. We're not going to give all that. Now, intuitively, you might think, I want to give my attorney in fact, that'll be managing the company, authority to handle money and finances. But remember, a power of attorney is for the individual as the principal, not as the company as a principal. So all the individual needs to do is give the attorney in fact the right to handle business transactions, because that will include the finances of the company. So we want a very limited power of attorney for our attorney in fact, and whoever's going to be handling something during our incapacity. Remember, a power of attorney has no authority after someone dies. The third document is going to be the transfer resolution, or if you preemptively approach it, the transfer provision in an operating agreement for an LLC. This is similar to like a transfer on death deed. Essentially, it's going to, or transfer on death deed appoints a beneficiary to take over the ownership of the property. A transfer on death or a transfer resolution is going to appoint somebody to manage the company during incapacity, or manage and own the company during post-mortem, during during the legacy period. Now, a couple things to note. This is essentially, if you don't have it already in your operating agreement, it's going to be a resolution that you'll pass with the company minutes. Pretty simple, but there's a lot that goes into it. Let's look at the transfer on death right now, because that's the most obvious one. We're going to transfer management and ownership to an individual or multiple individuals, possibly. If you do multiple, then it takes a little bit more work, but make sure that included in the transfer on death resolution, there is a way that the nominee can accept the role as owner and manager of the property. Remember that this is always revocable. While you're alive and have capacity, you can always amend the operating agreement or articles. One thing to keep in mind is after death, we have to deal with the Corporate Transparency Act. The Corporate Transparency Act requires beneficial ownership information reporting, such as if you bring in a new beneficial owner, which the successor would be, they have 30 days to file their BOI report with the IRS, or substantial penalties can be, the individual can be subject to substantial penalties, or the company can be subject to substantial penalties. If we're looking at incapacity, this is more of a limited transfer. Now, in transfer on death, we transferred ownership and management. And you could, of course, bifurcate that somehow with multiple people. But for incapacity, we're going to maintain ownership. And very specifically, you want to say, even if I'm incapacitated, I have ownership. But we're going to transfer management of the company during incapacity to another successor to take over. Make sure in the resolution to define what is incapacity. Generally, it's going to be a court says that you're incapacitated, or a doctor says you're incapacitated. However, some people have a board that can determine incapacity, or their spouse can say, yeah, you don't have capacity anymore. The other thing to remember for the limited transfer resolution is if you want to compensate the individual, make sure to write in there what their compensation will be. It's a lot of work to take over a company, especially when it's not yours and you're just stepping into these mysterious shoes. So make sure to compensate the individual. Otherwise, they may say, you know what, I don't want to do it. I love you, but no thank you. One last thing to keep in mind is there are professional service companies out there, such as the Professional Limited Liability Company. PLLC is going to be for doctor's office, dentist's office, accountants, law firms, that sort of service that is provided. Now, generally the statutes will say, yes, you can transfer, say, a PLLC to, say, your spouse, but who may not have the professional license to be able to run the business. Like, my spouse is not an attorney. She cannot own a law firm, but I can transfer it to her, and she has a certain amount of time to sell the company or transfer it to somebody else that does have the proper licensure to allow ownership of the company. So something to keep in mind if you're in that realm. So that's my take on very basic business succession planning. I hope you liked today's video. If you did like today's video, hit that like and subscribe button. It really helps support the channel. We do a new video every other week to a couple times a month. If you have any questions, leave them in the comments below or just send me an email. I'm happy to get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.